will be webcast and a record retained on the Council website. For those at home viewing the webcast, I'd like to inform you that if you look at the above video, you see a Resources tab. Select this and a link to the agenda will appear in the right-hand side, and this will allow you to open the agenda in a PDF format and follow the discussion and debate. My role is to ensure that the committee runs smoothly and having regards to the procedures, behaviour and ethics. Are there any... We've got some apologies, haven't we, Anne? Or Ken?
Sorry, Chair, yes. The apologies are from Councillor Gleaves and Councillor Spriggs.
That's it?
Yes, those are the apologies.
That's okay. Have we got any declarations of interest from anybody? No? So we'll go straight to item 2, which is the minutes. To approve the accuracy of the minutes of the meeting of the Licensing Act held on the 17th of June. And the minutes of the licensing panel. So is everyone happy that we agree those? Yeah. Okay. Thank you.
Okay.
Yes, Steve?
Thanks, Chair. The minutes of one of the, I think it was 24th of September, is showing me present and I wasn't.
Okay.
And the licensing panel.
Make a note of that, Anne.
Probably
We'll
just
make a
another
note
William,
of
was
that.
it?
Yeah, with that.
Okay, thank you, Steve. Anyone else? Would we have noticed? Anyway?
Other than that amendment.
Okay.
Chair will amend that for the minutes and
Okay.
record that Councillor Williams wasn't present and some other was.
Okay, thank you for that. So we can now move on to the main part of the meeting, which is the draft statement of policy under the Gambling Act 2005, which you'll find on pages 31 to 96. And we'll now move over to our licensing officer, Margaret O'Donnell. Thank you.
Thank you, Chair. The purpose of the report brought before you this evening is for this committee to recommend to Council the approval of the draft statement of policy under the Gambling Act 2005. The Gambling Act 2005 requires the Council to prepare and publish a statement of principles to be applied when exercising its functions under the Gambling Act 2005. It is a requirement that this policy document be reviewed every 3 years. The Council's current statement of policy was first published in December 2006 and has been subject to a review every 3 years since that date. Each review has been consulted upon and subsequently recommended to Council for approval by this committee. Members will have been provided with a copy of the draft statement of policy, and highlighted within the policy are amendments to the current policy, and those amendments have been highlighted in red. I can summarise the amendments to the policy as follows. In looking at the current policy, it was evident that we did need to update some contact details. There'd also been changes to the names of committees and panels. We've made it clear now within the new draft policy what our approaches and policy is relation to the withholding of personal details should somebody make a representation in respect of an application. We've provided additional section on test purchasing within the draft policy and on age verification. We've set out what the licensing authority's role is in remote gambling and provided further information in respect of who can apply for a licence and the information required, as well as additional information relating to the protection of children and vulnerable adults. And we've also made clear what is meant by available for use in terms of gaming machines. The draft policy was circulated for consultation. There are a number of statutory consultees, and it was also put on the Council's website. A list of the consultees is attached in Appendix 2 to the report, and the consultation commenced on the 1st of October and closed on the 18th of November. In response to the consultation, we have received a letter on behalf of the Betting and Gaming Council submitted by Goschalk solicitors, and they make a number of observations in respect of the draft policy. And Chair, with your permission, I'll go through those observations.
These are the ones you were talking about this afternoon?
Yes, Chair, yeah. There is a suggestion that in paragraph 15.3 of the policy, that is removed regarding what we currently say in respect of different areas, and reference is made in the same in paragraph 15.4. If members were to look at those paragraphs, what we actually say is whether or not we would have a specific policy relating to areas and how we would consider applications in particular areas. The paragraphs currently merely set out that we don't currently have a policy about where gambling premises may not be located, and the suggestion by the Betting and Gaming Council is that we don't have any reference in that regard, but we simply say that we will consider each application on its individual merits. Also, in paragraph 18.15, it is requested that we make it clear that when we're asking for details from applicants in relation to what measures they will have in place, that we make it clear that we expect those measures to be set out in a risk assessment, and I'm quite content to make that clear within the policy. Linked to that, I draw members' attention to section 19 of the draft policy, which is headed up conditions. And again, the Betting and Gaming Councils are suggesting that we have an introductory paragraph to that section, which again sets out what the Gambling Act says in relating to mandatory and default conditions, which quite rightly they say are designed to be sufficient to ensure that premises operate in a manner that is reasonably consistent with licensing objectives, and that additional conditions will only be imposed where there is clear evidence of a risk to the licensing objectives, which is not adequately addressed by policies, procedures and mitigation measures described in an applicant's risk assessment. And subject to members' views, again, I'm quite happy to add that to the draft policy. And just linked to that, the following sections 23, 25, 22 and 27, which set out the various requirements in respect of different types of licences. We are asked again to make it clear that applicants put details of their mitigation factors and their measures in their risk assessment. And again, I'm quite happy to adopt that approach. And that was their feedback, Chair.
You know the first paragraph you mentioned, which one was that?
The first one,
Oh, sorry, yeah. The first paragraph you mentioned, which one was that?
it's 15.3.
Yeah. When it says about areas,
That's right.
and I know they said you will be looking at each one on their merits as they come in. For example, what type of area would you say you wouldn't have? I mean, I was thinking of school, but then I thought you have function days where they have silly little gambling things, don't they? So what sort of place would you say, just out of interest, that you would suggest you wouldn't be having gambling?
I think that's probably the point being made by the Betting and Gaming Council, that there would be, it would be too generic to actually specify an area. What they say is location will always be relevant in the context of whether a particular proposal is consistent with the licence and objectives, rather than the area itself. That the existing policy did follow recommendations within the the Gambling Commission's guidance, and it is that maybe things have moved on now, and we haven't had any problems or issues in that regard, and it would not prevent the licensing authority taking into account factors within an area. So it might be, as you suggest, the location of a school may be relevant for a particular type of premises, or it may be that if the area has a particular problem with people who may be at risk from gambling, so we would have to look at statistics and information from other agencies in respect of whether or not having particular premises in a particular area, if there was, as I say, a significant risk to people who may have a, be more susceptible to being harmed from gambling.
Okay. Steve, do you want to say something?
Yeah, thanks. Exactly what Margaret's just explained. I don't see any reason to take 15.304 out, because that is covering exactly what's just been explained. We're not saying anything from the outset, but should there be an incident, each on its own merit, as you say, that would come into play. So I can't see why they're wanting us to take that out.
I agree with Steve.
Yeah, I mean, that is the purpose of this evening, Chair. It is a matter for this committee, having considered the policy in its entirety, for you to consider that feedback. There's no obligation on us as an authority to adopt suggestions made in that feedback, but we are under an obligation to consider that feedback.
Mike?
Yeah, thanks, Chair. Thanks for that, Margaret. I've got to agree with colleagues that, yeah, I think we could leave that in, but I want to go to section 20, talking about door supervisors. Now, it says if there's a concern about may attract disorder, there's two sections there, disorder and subject to attempts by unauthorised access.
Which paragraphs are you looking at?
Pardon?
Which paragraphs?
21, sorry, 20.1.
Yeah.
My concern is if it may attract disorder, and then we go to 20.2, that they may, whether these need to be SIA licensed or not, can't we do, if there's going to be a potential, or the risk has been decided that there's going to be disorder, can we say they need to be SIA licensed? Are we able to? Are we allowed to? The reason I'm saying that is an SIA licensed door supervisor has undergone a lot of training, whereas just a door supervisor doesn't have to have any training. And my concern is, especially if it's to do with disorder, they are highly trained, and they are highly trained with dealing with de-escalation and everything else, and conflict management, whereas just a door supervisor isn't. So is there anything we can put in there if the risk to disorder?
Thank you, Councillor Collins. I mean, very helpful observations, really. I think we need to ensure, obviously, there is a legal requirement for anybody acting as a door supervisor to be SIA registered in any case. So I think what we need to do is to really make it clear within that paragraph. Yeah.
Anyone else got any? Anybody else got any suggestions or made any comments? Could I suggest that Councillor Steve Williams has had to say with regards to the paragraphs, and that we agree with him that they should be left in? Yeah. Is everyone happy with that? Agreed. And with regards to the door supervisor, I think Margaret made the point that you have to be SI anyway to be a supervisor.
Just for checking.
I'll make that clear. Yeah.
Just for checking, Chair, it's paragraphs 15.3 and 15.4 that Councillor Williams commented on and took a view to, which was shared by the committee, to maintain the current wording as detailed and provided this evening.
You can't hear it out there.
Oh, well, I'm just saying the paragraph 15.3 and 15.4 is the two paragraphs that Councillor Williams has indicated should be retained in their current form.
Yes.
Okay.
Yes. It's all right.
Yeah, I've just noticed a typo. You know what I'm going to say, do you? 21 gaming machines. Okay.
Is that?
Yes, Chair, if I may take the liberty for a final read, we'll correct any slight typographical errors on the numbering.
Yeah, don't forget this is a draft.
Yeah, no, I had
Is that?
I
is
had
that your-
circled that,
Is
yes.
that you complete on that now?
It is, yes,
So is
thank
that
you,
it?
Chair,
Can we
yes.
finish on that?
Yes,
Okay, so can we say that we will adopt at the moment this draft policy? Can someone propose it?
I'm more than happy to propose, Chair.
Does anyone want to second it? Chris, okay. Is that it?
yes.
Agreeable, yes.
Yeah.
Chair, could I just clarify
Can we
that-
all agree that's on assent? Yep.
Yeah. Just for clarification, if possible, Chair, that does include the other suggested amendments from the Betting and Gaming Council.
Yes.
Yes, thank you.
Is that it?
Yes, thank you, Chair.
Okay. Unless there's anything else, thank you all for attending. And you can all go out into the rain.